This week, the 8th Circuit U.S. Court of Appeals heard an appeal in the Gun Owners of America et al. Versus ATF et al. In the frames and receivers redefining fiasco lawsuit. Before I jump into it, I want to thank the sponsor of the video, and that's Blackout Coffee. At Blackout Coffee, we have tons of coffees, teas, and hot chocolates, and I want to thank the more than 1,250 investors who joined our family. There's still a little bit of an opportunity if you check that link down below. If you want some of the best coffees, teas, and hot chocolates and some of the coolest swag around, hit blackoutcoffee.com/GNG. Look forward to having you try our stuff. So on the 14th, just a couple days ago, the 8th Circuit heard the case, the GOA versus ATF and the redefining of frames and receivers. And I'll have the audio down below. It's about 45 minutes. And the audio, for me, is concerning. It's not concerning in how Rob Olson of GOA and Attorney Smith of Montana pitched their case, nor how the U.S. Attorney for the ATF pitched their case. My concern is with the judges. Because the frames and receivers lawsuit, you have to have a knowledge of making a gun. Like, what is a frame? What is readily convertible? What is a receiver? What is not? And it was pretty easy prior to the ATF's new rule to figure out what was what and how you could do things. But the new rule has only clouded it up. In fact, Attorney Smith of Montana argued that there are 3 violations of the APA, the Administrative Procedures Act, in which groups pitch a proposed rule, and then comment period happens, and then the final rule is promulgated. But there were changes from what was pitched as what was going to be the rule versus what actually came out as the final rule. And the ATF seems to do that all the time now. But there was one broad definition in the proposal, but when the actual rule came out, it was 2 very strict definitions. There are also concerns about differences in examples and the inability of the public to comment on one thing that changed in the process as well. And Attorney Olson went over in great detail, well, in the limited time that they had. They didn't have the opportunity to pitch everything the way they wanted. But he went over how this violates our rights. But my main concern, like I said, with the judges, through their questions to me, showed me that they don't know anything about building guns. And one of the judges on the panel even said, shouldn't ATF get some deference in this? And the question, I don't remember it off the top of my head, but the one he was referring to was actually a changing of a definition. ATF should get deference in that. No, Congress has made the definitions. ATF doesn't get to change stuff. Congress does. And when the judge asked that, right away I was like, oh boy, we could be in trouble. But some of the other questions that went along when the U.S. Attorney was pitching his side kind of brought it back closer to the middle, but I'm concerned that these judges don't know what they're talking about when it comes to frames and receivers. So that was heard on the 14th. Link is down below. And I have one other announcement on this case that I guess is expected, but is going to be looked upon by the anti-gunners as a victory. And that's this post here. Yesterday, the new Attorney General for Arizona withdrew from this case that we're talking about. And she said, I believe this rule is within the ATF's authority and provides much needed regulation of ghost guns, which have proliferated in recent years and have made law enforcement's job more difficult and dangerous. The ATF rule modernizes the definition of firearm to make clear that privately made firearms and so-called ghost guns are included. Specifically, among other changes, the definition now includes parts kits that can easily be assembled into functioning weapons. Now, Arizona first joined this lawsuit under the previous administration in July of 2022, and now they seem fit to remove themselves because the voters of Arizona have voted in this liberal clown. So this case is still moving forward. We're still waiting to hear from the 8th Circuit. It's a 3-judge panel. And hopefully we'll hear something soon, but they're under no time constraints. They can take as long as they want, which is part of the crappy part about the judicial process. But GOA is pushing forward, and I really believe that you don't just change something that has been normal since prior to the revolution just because the anti-gun groups told your current acting person in the White House what to do. And because he's stupid and is beholden to his fundraising people, that's what the ATF has been ordered to do, and that's what they've done. They've changed the definitions of frames and receivers. They've changed the definition of machine gun. They're changing the definition of short-barreled rifle and short-barreled shotgun. And based off of Joe Biden's newest executive order, they're going to be changing the definition of federally licensed firearms dealer. These are all things that Joe Biden is pushing because he can't get them done through Congress because they're unconstitutional. They're illegal. So he's using the executive order process to circumvent law, which is also illegal and unconstitutional. What do you guys and gals think down below when this decision does come down? You know I'll bring it to you. And if you want to stay in the loop, then subscribe to the channel down below. Like the video and share it so more people see it. Check out blackoutcoffee.com/GNG, and thank you for your time. I appreciate each and every one of you more than you know. Until we see each other again, be safe, stay vigilant, and carry a gun to keep you, your friends, your family, your community safe. I'll see you all in the next one. Take care.